Good afternoon. Hello.
That one will probably do you better.
You think?
You might have better results with that one if it still has battery. This one,
They,
I think. There it goes.
oh, okay, I'll stay glued to it. First of all, I want to thank you all for coming. I'm going to help, for your enjoyment, point out a spelling error in our slide that says that sunshine is not spelled right, and that's partly my dyslexia. And I'm serious, dyslexia is a really interesting thing to have when you're a writer. My name is Patty Brown. I'm the editor of the Estes Valley Voice. I'm going to introduce our speaker here in a minute, but I'd like to real quickly introduce a few of our journalists that are in the room. I'd like to introduce Elizabeth Sherwin, who writes for us and does most of our book reviews. I'd like to introduce Barb Boyer-Buck, who does civic reporting for us, civic affairs. And I just saw, where are you, Hank? Oh, Hank Lacey in the back. He does a lot of court reporting, legislative reporting. He's also here with us as well. So thank you very much. Thank you to so many of you who are here. Oh, and we've got an editorial board member sitting over here, Sybil Barnes. And we've got a columnist here, Dick Mulhern, who does our editorial cartoons, or cartoonist, I should say. Is there anybody else affiliated with the Estes Valley Voice? Jim is also, Jim Jameson, an attorney on our board as well. So Estes Valley Voice is well represented here today. We also want to thank, we have two mayors in the room today. We have the mayor of Loveland with us and the mayor of Estes Park with us. We have some town trustee members. We have several people who sit on elected boards in the room and also appointed boards. So this is awesome to have so many of you here interested in learning about open record and open meeting laws in the state. So I'd like to introduce our speaker, Jeff Roberts. Jeff is the executive director of the Colorado, I know it, it's an old habit, the Colorado Freedom of Information Coalition. And with that, I'm just gonna hand the mic to him and let him get started. Thank you.
Thank you. Good. Okay. So as Patty said, I'm Jeff Roberts, Executive Director of the Colorado Freedom of Information Coalition, which is a nonprofit that's been around actually since 1987 that educates journalists and the public at large about their rights under the open government laws. So the public records laws, the open meetings law, court access rules, and we also advocate for better government transparency. So we work in the legislature. It's the session right now, so it's a frantic time, and there's always a bunch of bills. Can you guys hear me okay? Okay, good. There's always a bunch of bills that relate to open government issues. So our website, I should also mention that I am not an attorney. I've been dealing with these issues now. I've been on this job now for almost 12 years. So I'm very familiar with them. We have attorneys on our board who I've learned a lot from. My background is journalism. I spent 23 years at the Denver Post as a reporter and editor and at other news organizations. So that's the perspective I come from. I should also say that the workshop I'm going to talk about or do, I usually do for journalists, the public at large, students, less so public officials. So just to let you know that that's the perspective I come from, is making sure that people know their rights under these laws. But I think it's also very useful for people who serve on boards and commissions to know as much as they can about this stuff, even if they might have gotten some training from CML or some organization like that. We go very in depth in this stuff. I deal with this every day. Part of my job is to run a hotline, what we call our Freedom of Information hotline. And I've responded to 6,500 inquiries to the hotline. So that's a few a day, and I'm dealing with these issues quite a bit all the time. So this is our website, which is coloradofoic.org. And there is quite a bit of information on this website. One of the things I do as a former journalist is I kind of treat open government as my beat. So I write about open government issues, often court rulings, cases that are in court that have to do with open government issues, issues in the legislature, or just other issues that are related to open government or press freedom. We are also advocates for press freedom. So you'll see, like the latest thing I wrote about had to do with a request for records about water consumption at very large AI data centers. And the cities of Denver and Colorado Springs, or their utilities, denied these records, but judges have recently said, no, these things are public. I kind of expect this to be appealed, and we'll see if it makes some case law in Colorado. The other thing that I really want to point out here is our Sunshine Laws Guide. So this is something we used to do in booklet format about 3 years ago. We put it online, and it is very, very comprehensive. It is searchable, indexed by topic, links to case law, links to statute. What I really like about this is I can keep it up to date. So a new law in the legislature, from the legislature, I can add that in pretty quickly and explain that, or some Court of Appeals or Colorado Supreme Court decision that affects the law statewide, I can add that in there. So everything I'm going to talk about today is in here pretty much. So you can always refer to this, and you can always contact me. That's a lot of what I do. So I'm always happy to answer questions, and if I don't know the answer, I have resources where I can get the answer. And also, oops. Okay. As I'm talking today, feel free to ask questions. I think that's probably better than saving them till the end. So, I just want to make sure that's there. So we have, what I'm going to talk about are the laws that, this is your legal grounds for access. So we have the Federal Freedom of Information Act, which was enacted in 1966. I don't really deal very much with that. There are other experts with this. There's plenty to do for state and local government in Colorado. I'm never looking around for things to do. There's always stuff going on, especially when the legislature's in session. So what we're going to focus on are the Colorado Open Records Act, which has been around since 1968, passed not too long after the federal FOIA. If we have time, we're going to get to the Criminal Justice Records Act, which has a very different presumption of openness than the CORA, the Colorado Open Records Act, for police records. Those are issues that come up very frequently as well. And then there also is there are separate rules for court records, separate rules for the records, the administrative records of the courts, and then there's the open meetings law. And that's what I'm going to start with. And you've had some issues or court issues very recently in Estes Park that relate to the open meetings law, and we could talk a little bit about that. So I always like to begin by sort of stepping back and thinking about why this matters, why any of it matters. Why do these laws exist? And this is a quote from a Colorado Supreme Court ruling in 1983 that I think sums it up really well. For a free self-governing people to understand how to vote intelligently in elections and to hold government accountable and to compel officials to act responsibility, they need access to information. That's what it's really all about. And so that's why we have these laws. And we always need to kind of keep that in mind, that that's what it's for. So the open meetings law. I did this article for my blog when on the 50th anniversary of the passage of the Sunshine Act of 1972. So that's a couple years ago now, almost 3 years ago now. And I wrote about, actually I put kind of a personal spin on it, because it wasn't just the open meetings law. The Sunshine Act of 1972 also included public officials' disclosures and lobbyist disclosures. So at the Capitol, I started at the state Capitol for the Denver Post in 1985. So definitely dating myself. But I entered the press room of the Denver Post. Back then we had our own big room that we could use. And there was this old roll-top desk that I was given to use, and I was told it had belonged to a Colorado Supreme Court justice. So what's the first thing you do when you get a roll-top desk to use? You start opening the drawers and looking inside, and what was in there but bottle openers with Coors stamped on them. And so that was, and there was also a refrigerator in the room, which didn't work anymore. So these were remnants of another time at the state Capitol when things were a lot more closed, and reporters would go in the Denver Post press room and play poker and drink beer and wait for legislators to come out of private caucus meetings so they could try to find out what happened. The open meetings law and the lobbyist disclosure law changed all that. So there was a reporter for the Denver Post named Fred Brown. Fred is in his 80s now, and he serves on the board of the Colorado Freedom of Information Coalition. So he's still very active. But Fred, as soon as these lobbyist disclosures were made public, he started pouring through them, and he wanted to write about it. So he wrote a story about it. In about the second to last paragraph of the story, he wrote about $140 a month that the Colorado beer distributors spent on beer for the state Capitol press room. So as soon as that came out, that was the end of that. And Fred lost some friends, which I think he regained eventually. But it was something that needed to happen. That was the old way of doing things. But that's why I found bottle openers with Coors stamped on them in my desk. And that's how I wrote this story. Anyway, so Sunshine Law, the open meetings law, is 52 years old. It starts with a very powerful statement, I think. It is declared to be the policy of the state that the formation of public policy is public business and may not be conducted in secret. That's what it's all about. Congress doesn't work that way, but the legislature is supposed to work that way, or was. And local government public bodies and other state public bodies are supposed to work that way. That's what the people of Colorado said they wanted. And these laws, in one form or another, are in every state. So this is from a very recent Court of Appeals ruling. This attorney, kind of a controversial attorney in Pagosa Springs, has been suing school boards for violations of the open meetings law mostly. We don't necessarily, think that's the best business model. He believes in what he's doing. He thinks his job is to hold government's accountability. But there was one of his lawsuits got appealed to the Court of Appeals, and we actually supported his right to do that because, as the Court of Appeals said, transparent government is for everyone. So it doesn't matter where you live in the state of Colorado. If you see a violation, you can try to challenge it in court, and that's what he's doing. I think that that's an important thing because a journalist, for instance, or a news organization, which may not be based in that particular town or city, may see a violation that needs to be challenged. So the open meetings law, it pertains to any kind of gathering in which public business is discussed. So that could be meeting in person, like we're doing right now. It could be a phone call. It could be any other kind of electronic meeting. Of course, these days, we have public bodies meeting on Zoom since the pandemic, but it could also mean email, text message, disappearing messaging app like Signal, things like that. And for a local public body, so a city council, a town council, a school board, a hospital district board, a fire board, it's 3 or more members are discussing public business that pertains to their policy-making function. That's what the courts have said is how public business is defined. Then that's a meeting that's supposed to be open to the public. But if you do that by email or text message or by phone, there's no way really for the public to participate in that. And so that's why people have to be sort of on guard about these things. For a state public body, it's 2 or more members. That includes the legislature, but as you'll see, the legislature just changed the rules for itself last year. Let's see. We have covered that. It really is not just any council or school board. It's also things like advisory boards and things like that. If the board creates another entity that advises them or something like that, they're covered as well. Yeah. Yes, yeah, and an appointed board is also is covered as well. Right, but that it's still the way the law is written, they're still covered by that. Yes. As I mentioned, it must have a meaningful connection. The content of the meeting to be considered public business must have a meaningful connection to the policy-making responsibilities of the board. Yeah. For the open meetings law, it's 3 or more. For the advisory board, a quorum rule would be something that would be set by the public body itself. Yes, or it's 3 or more, or a quorum, whichever is fewer. Yeah. I'll get to that. That's kind of a controversial thing. Yeah. It does. There's no differentiation in the open meetings law between a regular meeting of a council or board and a study session or what's sometimes called a work session. It's just an open, 3 or more, or a quorum, whichever is fewer. So staff is different. Staff is excluded from the open meetings law. It's the public body itself that we're talking about. I won't spend a lot of time on this, but the legislature, as you might have heard or read, exempted itself from a lot of this last year. We weren't terribly thrilled by that. We oppose that, continue to oppose that. What the legislature did, they decided that the way the open meetings law has been written is not the most efficient way for them to operate, but there were also a couple of lawsuits that led to this. They changed the definition of public business as it applies to them. So it's not the same thing that case law talked about, where it has to just relate to your policy-making function. For them, it's much more specific about bills and what's coming up in the legislature, things like that. And they also changed their ability to communicate electronically in an unlimited way without it being a meeting under the law. That does not apply to local public bodies. We think that that's a problem because there's a lot that could be done that way and the public would never know. Even though you could do a Cora request potentially for those messages, they either may not exist or they could be covered by some exemption in Cora. We think that goes definitely against the spirit of what the open meetings law is supposed to be about. Yes. The open meetings law? No, they are not subject to that. Yes. Yes. Yeah, the governor is not a public body. The governor's communications may be subject to Cora, the Open Records Act. And so you potentially could get records about that. They may cite some exemption to withhold them, but the meeting itself is not an open thing. How did that come about for the legislature? Well, it was very unusual. There, 2 members of the House itself sued their own House because they felt like 2 things. The caucus meetings were not being properly noticed, and that legislators were using this app, and still do, called Signal to communicate with one another, and the messages are just set to self-destruct. So there was a settlement of this lawsuit, but that is completely out the window now that they've changed the law. There was also a lawsuit that was brought by a conservative group related to a system that the legislature was using called quadratic voting. And this was a way that they were ranking bills that affected the state budget. And this was all done anonymously. And so reporters found out about this and did stories about it. KUNC was the main outlet that really focused on this and did a great job. And then tried to get the records of it and were denied. So this was something that we thought violated the open meetings law. We don't go to court. We don't sue. We file amicus briefs at the appellate level, but otherwise we don't do that type of thing. But this other group did, and the legislature lost this lawsuit. So what do? They changed the law to allow them to do this. And what's the result? The special session that happened last August on property taxes, they had the Democrats, and I think maybe one of the Republican caucuses as well, had meetings that they closed to the public and the press for the first time in decades, I think. They used this law to close their meetings, even though there's a Colorado Supreme Court ruling, that 1983 one that I quoted from earlier, that says legislative caucus meetings are open to the public. I get really dry, so I need to take sips. Yes? Yeah, he signed it the next day. They also did it. Yeah, exactly. They also did it during Sunshine Week, which is something that has been celebrated for about 25 years in the middle of March. It's around James Madison's birthday, and that's when they did it. It was really, I'm sure I don't know if they were thinking about that, but that made it hit a little, yeah. Not necessarily. The one thing that may happen, I actually had a meeting with the speaker about this about 3 weeks ago. They might try to change the Cora to extend or create some sort of records retention for legislators' messages. We'll see if they actually do that. There are still, even if they do that so that the messages actually exist, there are still exemptions for things like work product that could exclude those from Cora. So I'm not even sure that you'd be able to necessarily get them if they exist. Yeah. I know they do, and I have heard a little bit of that some other, some local public bodies are interested in that. We would certainly fight that. We'll see if that comes up. So far, it hasn't. Notice and minutes in the open meetings law. Notice is required for, it's a much more nebulous kind of thing for a state public body. It just says full and timely notice to the public. But for a local public body, that means 24 hours ahead of time to be noticed. And the law is still kind of antiquated. You can post it in this building somewhere on the wall, or you could put it on the internet. Of course, you should put it on the internet these days, right? And you should put it on your social media, and you should make sure everybody knows about it. And then there is some case law about how sufficient that notice is supposed to be. It's considered a flexible standard, but it should be actually the subject matter that's actually considered at the meeting should be reasonably related to what's on that agenda. So I hear sometimes about agendas being changed at the last minute and things like that. And that really should only be done if it is absolutely necessary. There's some, emergency thing that comes up and it can't wait until the next meeting. If the public doesn't know that it's supposed to come up. Minutes are supposed to be taken only at meetings where there's the adoption of any proposed policy, position, resolution, formal action, etc., or that could occur. That's why sometimes for study sessions there aren't minutes, because they're not doing formal action. But that is what the statute says about that. So here's an example of a case that went to court because the agenda was worded in such a way that nobody could know what was going to come up. This was the Woodland Park School Board a few years ago, and they were considering a memorandum of understanding with a charter school that was kind of controversial. But they put it on the agenda under this. It just said board housekeeping. That's all it said on the agenda. So if you weren't, very intimately familiar with what was going on, with the school board and hadn't talked to people, you wouldn't know. The average person in the community would not know that charter school was coming up if you just looked at the agenda and it said board housekeeping. So a parent took them to court and got a ruling that said that if you're going to talk about this charter school, you've got to tell the public you're going to do that. Pretty common sense thing to do, I think. Pretty normal thing that if you're going to talk about something, say what you're going to talk about. I think that's all it came down to. There's an open meetings lawsuit going on right now in Elbert County. Excuse me. The county commissioners there gave significant raises to the county attorney and the county manager, just totally outside of any kind of public meeting or the process where they're supposed to do that. And people in the county found out about it. And there's a lawsuit now about that, including one of the one of the plaintiffs is a former county commissioner who's pretty upset about this. This is still ongoing, so I don't know how it's going to play out, but these things have to come up in public meetings. They have to, I mean, there are certain things that can be discussed in executive session. We'll get into that a little bit, but you can't just do this totally outside of the process. There's a provision in the open meetings law that says that county commissioners do not have to notice certain meetings if they have to do with day-to-day oversight of county employees. I think this is a kind of an antiquated provision in the open meetings law, mostly for small counties that didn't have county administrators, things like that, and the commissioners had more of a role in daily oversight. I think that's what that was for. But the Elbert County commissioners cited that to say, oh, we could give big raises to these employees, totally outside of public view, totally outside of a meeting, and so we'll see what a judge says. Yeah, I'll get into that a little bit, but the main thing to know is that in Colorado, these laws are enforced in the district courts. So we don't have a place to go, in some office you go complain to or anything like that. The AG doesn't handle these issues. The Independent Ethics Commission doesn't handle these issues. They're in the courts, and I'll get into a little bit about what the penalties could be. Yeah. Yes. Yes. Well, so we, every once in a while, we have a University of Denver law student do a research report for us. We've done about eight of these. And the very first one we did, I want to say like 9 years ago, was have a law student look into all 50 states that have some sort of administrative appeals process. And there are very few that work very well. There's one in Iowa. Yeah. And I think, yeah, I think it's like it's got kind of a reputation. So the main thing is if you're going to do that, it has to be independent. It has to be pretty independent. Their decisions have to mean something. They can't just always side with the government. They have to be impartial about these issues. So, if you have them in the Attorney General's office, like Texas does, that particular Attorney General may influence how they act, right? So I think if we're going to set something like that up in Colorado, we have to be really careful about it. Right now, there's no way that could happen because it would cost money. And there's no way the legislature is going to spend money on practically anything right now that they don't have to spend money on. It's just the way the budget is right now. So we're not pushing for that, but if we did push for it, we'd have to put a lot of thought into it, I think, how it would work. Emailing and text messaging. So I mentioned that the legislature, if you're in the legislature, you don't have to worry about this. But if you're if you're a member of another type of public body, a local or state, you do have to think about emailing and text messaging amongst yourselves, because that could be a meeting under the law, and it's that three or more thing again. So members of boards and commissions, if they're emailing, text messaging one another about public business, again, defined as something that you have some sort of policy-making function related to it, that could be a meeting under the law, but it's not a meeting that the public can attend. There are some rules in the open meetings law specific to elected officials about what types of things that you can share that don't relate to the merits or substance of public business. That's a provision that's only about 5 or 6 years old in the law, but it was trying to clarify things like you can schedule things. You can maybe share a bit of information that was passed along to you as long as you're not discussing merits or substance. So those disappearing messaging apps, we had one of those law students do a report on that as well. We think that those are very problematic, and I don't know how pervasive they are with local government officials, but the people in the legislature use them a lot, Signal, and they use it to communicate with lobbyists and themselves. And I've heard that in some local governments are using these as well. And the problem is that it's an easy way to evade the open meetings law. It's also a really contrary to what the Open Records Act is about, because we already have actually very weak records retention. Basically you have, so I'm sure that Estes Park has probably adopted the records retention schedule of the state archivist, and Loveland has done probably the same thing as well. So there are certain things that you have to keep for certain periods of time, but if you use a disappearing messaging app, set it to self-destruct, immediately or in 24 hours, you're kind of thumbing your nose at those, records retention laws. Somebody brought up serial or daisy chain meetings. This is interesting as well. So, and we don't have case law in Colorado about this. We almost did, because there was a case that you might have heard about involving 4 members of the Douglas County School Board. So what they did was, and this is now 3-4 years ago, 4 members, so the Douglas County School Board, and it may still be like this, was 4 members were, all together on a lot of things, and 3 members were in the minority. And so the 4 members communicated with one another by phone, a series of one-on-one conversations to talk about the school superintendent and what, they didn't like how he was doing things. And they eventually had enough conversations where they decided he should be fired. So this was all done outside of a public meeting without the 3 other minority members. And that's essentially the definition of a serial or daisy chain meeting. Series of one-on-one meetings discussing the same issue where the thoughts of one council member or board member are related to a second and a third or a fourth. And it doesn't even matter if you make a decision. If you're doing that and you're talking about public business, that is a serial or daisy chain meeting. And a district court judge in Douglas County thought so too, and thought it was a violation of the open meetings law. This case went on for a long time, but that's what he ruled. So it did not get appealed. So we don't have the Court of Appeals or the Colorado Supreme Court to say this applies statewide. But I think it's an interesting thing for public bodies to look at and look at what the judge said and think about how, are they, should we be doing this or not? The judge in that quadratic voting case about the legislature also decided that was a serial or daisy chain meeting that violated the open meetings law. So we've had kind of 2 district court cases that relate to that. Yeah, and you've had that issue, that very issue in Loveland, and you even had a kind of a special investigator dig into this, correct? Um, and there's a difference of opinion on this, right? Because that person, I think, eventually dropped it. Yeah, I actually watched some of that. Yes, yeah, I watched some of that. Yeah, yeah, and is that the issue that is currently still in court? Yeah, yeah. It seems like it would be a bit of evidence of that. The, well, yeah, right. And there's a similar thing going on right now with the the Wildlife Commission and a letter to the editor that was drafted by some of the members related to the the ballot question we had on the cats. Um, that's in court as well. And so I think we'll watch that too and see, because they're kind of related or kind of similar in that respect. Um, what can you do outside of a public meeting, and does it extend to something like that? It would seem so, but let's see how that plays out. Yeah, 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 yeah. Because yeah, yeah, you could. Yeah, there was an opportunity to do all that in a public meeting. Yeah, yeah. Um, so executive sessions. The open meetings law provides for certain circumstances when you can close the door. Um, that has to be done in a pretty specific way, and there's case law about that. So the idea of closing the door on the public is a pretty significant thing. And in 2001, it's kind of hard to believe it wasn't part of the law before that. There was a process put into the law that tried to make sure, it kind of put some guardrails on this, tried to make sure that the public body tells the public something about what's going to happen behind closed doors. And the point of that is to give the public some information, but also to kind of give the public body itself some guardrails so that they don't go off topic and violate the open meetings law. So what has to happen, and if you're on a board, you know this already, the authorization in the open meetings law has to be cited. So the CRS, but in addition to that, and this is in a public meeting right before you go into executive session, it has to be announced to the public. You have to give them something, some specific information about why you're going into executive session without ruining the point of going into executive session. And then you have to take a vote to do so. So there have been some court cases about this. The most recent case law was in 2020 involving the town of Basalt. And they had an issue with their town manager, and just put on the agenda and during this public announcement, we're going to go get legal advice. But legal advice about what? We're going to get legal advice from our attorney. Well, the Court of Appeals said, you can't just say that. You got to say, it's about the county attorney. It's about, maybe his contract, something like that. So the public has an idea. Yeah. Generally, I think the public body is allowed to invite people into the executive session that it wants in there. The issue can be, it gets problematic when, for instance, there's an issue where there might be um, an adverse party. So there was a lawsuit, and I'm always thinking of in terms of things that have gone to court. There was a lawsuit involving, I think it was Pagosa Springs, and they actually brought a developer into the executive session that they were negotiating with. You can't do that. You can't negotiate with an adverse party or an opposing party in executive session. You could have people from the city staff. Sometimes you could have, some other expert that you need on something. The other thing you have to keep in mind is, some executive sessions may be for attorney-client privileged information. If you have a third party in there, you could break that privilege. So executive session, oh, sorry. I think if that could be proven, that could break a privilege. It seems. I'm not an attorney. I want to say that. So I'm not an expert on attorney-client privilege, but that is, I think there's potential for that. Yeah, there's interesting questions about, what can you say? What can members of a public body come out of executive session and talk about? Well, they have a First Amendment right to talk about it, but certain things like that could break attorney-client privilege potentially. So that's why you have to be careful, I think. So there's a case involving the Aurora City Council. Can't remember if I have a slide about this, but this one is in, I think, the Supreme Court right now. There's a very prominent member of the Aurora City Council who's been on the news a lot, but she was going to be censored by the city council a few years ago for stuff she was saying about the police chief. The city council in executive session actually decided not to censure her. And that's something that you're not supposed to do, make decisions in executive session. A couple of the council members came out of that executive session and told a reporter for the Aurora Sentinel that's what happened. And so they talked about something in an executive session. That was an okay thing to do. They had a First Amendment right to say that. And that, of course, that reporter called me, and I got one of the lawyers involved in it, and that led to a lawsuit. And that's the Aurora Sentinel has won at every step, but the city has appealed a couple times. So there are certain things that you can talk about. Maybe some others you shouldn't. Like if you're a school board, you can't come out and talk about a student because of their FERPA rights. So there's a bunch of things in the law that are authorized topics for executive sessions. There's several things for state public bodies, and then for local public bodies, there are various things like property transactions, conferences with an attorney on specific legal questions, personnel matters, things like that that we've already touched on a little bit. Negotiation strategies, but you can't do the actual negotiation in executive session. And then you can't adopt any proposed policy, position, resolution, or take formal action in an executive session. That is not what executive sessions are for. That stuff has to be done in a public setting. So this is a very, at least in Denver, a very high profile example of that. We had at East High School, which is actually where it's like 2 miles from my house. My daughters went there many years ago. We had a student who shot 2 administrators. And the day after, the Denver School Board went into executive session for 5 hours. And they came out of that executive session with a brand new policy on whether to reinstate armed police officers in high schools, because that hadn't been allowed. The shooting happened, they decided to reinstate it. That was all done behind closed doors. So they're in executive session for 5 hours. I start getting all these questions from reporters, and they come out of this thing with a brand new piece of paper policy. They have no discussion in public, and they just pass it. And so 6 news organizations sued and got the executive session recording released. So you asked what's one of the things that could happen if you win an open meetings lawsuit. And one of the main things that could happen is that the recording of an executive session can be released to the public. And so you could actually hear how they developed that policy that they should have been done in the public. Yeah. If there's no recording? Yeah. Well, they don't have to record that attorney-client stuff. They can turn the recorder off for that. If they forgot to turn the recorder on, that's a violation. I mean, there's a little bit of leeway in the law for if the machine doesn't work, something like that. But if they purposely didn't do that, I think a judge would issue an injunction or something like that. There are no penalties other than the plaintiff would get awarded attorney's fees and court costs. It's audio, and it needs to be kept for at least 90 days. I think that's not very long, but there's really only 2 ways that an executive session recording can be released. One is a judge orders them to do it. The other way would be that the public body decides itself to do it. The town of Florence, I don't even remember, a few years ago, they had all sorts of problems. Every member of the council resigned, leaving only the mayor. So they'd had so many complaints. You're worried about that. They had so many complaints about executive sessions that they just released the executive session recordings of a bunch of meetings. I think it was 7 meetings or something, without anybody suing. Oh, how did that happen? It happened, I think it's like right prior to them all resigning. Things were just falling apart, and somehow, somebody's complaints got that to happen. So it happened in Glenwood Springs once too, I think. So really close to home, you had a lawsuit that was brought by the Estes Valley Voice against the fire district. And it was about this issue about making a decision in executive session. So the decision to hire a new chief. Once again, these things are supposed to be done in a public setting. And Patty would say, this is not something she wanted to do. But it was, and the Voice won this lawsuit, represented by Steve Zansberg, who is CFOIC's board president, and the main First Amendment media lawyer in Colorado. So, it's just, once again, these laws are, the only way they're enforced is in the courts. And so sometimes that's what has to happen. Yeah, and I don't know if that's a training issue. The attorney who advises them, if it's, it actually ultimately probably rests on their attorney to make sure that the board, the council, knows how they're supposed to abide by the statutes. There are some states that require open government training for public officials. I think Florida is one of them, but we don't have that. Right. Well, what did they actually do in the executive session? I mean, they could discuss as so this is a question too, whether a personnel matter applies to someone who hasn't been hired yet. But I think courts have said that that's okay. There isn't actually there's a specific exception. I wonder about that because what the legislature has said is that it's okay for school superintendent candidates to do that in executive session if you have a public forum as well. So it makes me wonder, is it not okay for other types of people they're hiring? It's not super clear about that, but so you could have this discussion and then you could come out in a public setting and say, yeah, I like this person, or I don't like this person, and let's take a vote. And also that vote cannot be by secret ballot. There's a prohibition against that in the open meetings law. It's passed in 2012, I think. We had several public bodies that were doing that, and that is a violation because the public doesn't know that council member X voted for this person and this one didn't. No, it's not supposed to do that either. There's case law about that. Even informally, they're not supposed to do it. Well, you choose your words, the words you want to say in the public session, right? I think that's right. Yeah, I think that's right. Yeah, yeah. Just to recap, common violations, ones we hear about, sometimes they get litigated. Making decisions in executive session like you had here. Discussing public business by email, text message among a quorum or 3 or more members, using secret ballots. I haven't heard about that happening as much as I used to. Failing to follow the required procedures for going into executive sessions, serial or walking quorums, and then discussing a topic in executive session that is beyond the authorization in the open meetings law. I think it was Glenwood where I can't remember what prompted, I think it was pressure from like was actually pressure from the DA and some other local officials. And I can't remember the topic, but they ended up voting to release the executive session recording, and they went way off topic in the executive session once it was publicly released. And people were not happy about that. And then what could happen to you if you lose one of these lawsuits? There's not a ton of teeth in the law, but the disclosure of a recording of an illegal executive session could happen. If there's some action that was taken, it could be invalidated, court injunction, and then probably the other thing that's really important, both for the open meetings law and Cora, is that the prevailing applicant, gets their attorney's fees and court costs. Because otherwise, who's going to bring one of these, right? So let's see. So now, any other questions about open meetings before we start talking about Cora? Yeah. Right. I think it comes down to like, nod your head, raise your hand if you think this is the person we ought to hire, or you think that we should stop the censure proceedings on this council member, or we should come out of this and vote to have a new policy about armed police officers in schools. It's some kind of informal to formal consensus that you've built in that executive session. If people just are talking and say, yeah, I think this is a good idea, and it's obvious, that's one thing. And then you come out and you have a discussion in public about how you feel about it, and you let the public know about it. I'm sure there are executive sessions that happen all the time where the council, it seems like, and you know this better than anybody, or maybe it doesn't happen in Loveland, but it seems like everybody's on the same page, but they're not like raising their hands and nodding and all those things. Yeah. 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 Or whatever the issue is. Yeah. 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 And you give the public an understanding of why you came to that decision. In the case of the Denver School Board, they had no public discussion at all. Such an important topic as that, right? Armed police officers in high schools. Yeah. Yeah. I can't remember what the case is, but I think there is some case law about, and it has to do with, and this is actually in the Supreme Court right now, about what's meant by a cure. So that's a whole other issue I wasn't going to get into, but this is not in the open meetings law. This is court decided law about whether a public body can, quote, cure a violation of the open meetings law at a subsequent meeting. And that's the case that I think talks about what actually needs to happen in public. And it says something about, I don't know if these are the right words, but a robust discussion of the topic. Obviously, you can't make a particular council member or school board members talk if they don't want to talk, but there should be something that there just should be that discussion before they, otherwise it's really obvious that this was all done outside of the public setting. Yeah, and that's what the open meetings law is about. It's about giving the public that information. I don't think it's. I mean, I've never been a public official. I never will be. Never been on a board, but it doesn't seem like it's that hard to comply. It really doesn't. So Cora. So Cora, we have two public records laws in Colorado. The one that covers everything except law enforcement records is the Colorado Open Records Act. Applies to state government, applies to all local government entities. And if we have time, we'll get to the Colorado Criminal Justice Records Act, which is different and works pretty differently than Cora does. And sometimes people don't remember that there's a separate Criminal Justice Records Act and they just Cora for police records when they're not supposed to. So Cora also has a pretty broad declaration at the beginning, like the open meetings law does. All public records shall be open for inspection by any person at reasonable times except as provided in the statute. So what that means is that there's a presumption of openness of public records, the records of state and local government, unless an exception applies. So those exceptions may be in Cora itself, or it could be somewhere else in state law. Often it is, or it could be in some court decision, actually in some case law. But you can, and I think that people, when they make Cora requests, and I tell this to reporters all the time, assume that you're going to get the records you want. Because if you don't get the records, you're going to, and you're entitled to an explanation of why not. That's your right. So what's a public record? These days, it is very often something digital. That's how pretty much all records are created now. So it could be an email, it could be a text message, it could be a piece of paper, it could be an audio, it could be a video, it could be a Zoom recording, it could be a Slack message. Just think of like any possible way that government is keeping information or maybe communicating information. And it's anything that is made, maintained, or kept by that entity for the exercise of governmental functions or involving receipt or expenditure of public funds, which I think fits under the first part. So it's pretty much anything. So there is a response time in Cora, which is 3 working days or less. That's what's in the law currently. We'll see if that changes, unless extenuating circumstances apply. And that is spelled out in the statute of what that means. And then the response time can be extended by another 7 working days. So that response time, we'll see if that gets lengthened. There is a bill in the legislature right now, and there was last year that you might have heard about, that is the sponsor of it is Senator Kathy Kipp from Fort Collins, and she is very interested in addressing what she has called the abuse of Cora. And so what that means are, in her mind and in the mind of a lot of people who work for government, there are people who overwhelm governments with Cora requests. So this bill would extend the deadlines. A problem we see with that is that no one ever sues over delayed Cora requests. And if you think about it, by the time you would resolve a lawsuit, it would be well beyond the time you would either eventually get the records or the records would be useful to you. So it's not something that people sue over. And in fact, we just had a Court of Appeals ruling 2 weeks ago. This didn't relate to Cora, it related to the judicial branch's administrative records. And because there's a separate set of rules for access to those. And the Court of Appeals ruled that you cannot sue over a delayed request for judicial branch administrative records if you eventually get the records. So I think if one of these cases went to the Court of Appeals on Cora, they'd look at it the same way. And so the requester is already kind of at the mercy of the government in a lot of ways. And so that is one of the reasons we oppose it. The main reason we oppose it is there are already very big obstacles to obtaining public records in Colorado, and cost is the number one obstacle, I think. So before 2014, there was nothing in Cora that said anything about what governments can charge for what's called research and retrieval. So that's pulling the records and sorting through the records to make sure that they don't put out something that they either can't put out under the law or they have discretion not to put out. So you had some governments charging $20 an hour, you had some charging $80 an hour, some charging $200 an hour. So there was some case law about this that said a reasonable fee was $25 an hour. The legislature in 2014 said, okay, let's set it at $30 an hour, and we're going to allow that to be changed with inflation every 5 years. So what the legislature did not do, the reason this has not worked very well, is that they did nothing about the number of hours that rate can be multiplied by. So $30 an hour times 2 hours times 5 hours times 20 hours. The first hour is supposed to be free, by the way. It can get very expensive. So in 2019, it goes up a little bit with inflation. Last July 1st, it goes up way up with inflation. It went from $33.58 an hour to $41.37 an hour, which is where it is now. That's the maximum. I don't know if Estes Park has adopted the maximum, but 340 governments in Colorado have, according to my last count. So you're talking about requesting public records and maybe being charged hundreds or thousands of dollars for those public records, which technically belong to all of us. So there was just a column in Colorado Politics written by a former RTD board member named Natalie Menton. And the lead of her column was like, imagine requesting records about what your government is doing and being charged what your mortgage payment is. And that happens. So we think that is already a big obstacle in the law. We'd love to get the legislature to re-examine how this is calculated. We have been unsuccessful in getting anybody in the legislature to do that, mostly I think because they get Cora'd. They find it annoying. So before we extend the deadlines and do other things, let's do something about the cost. That's how we look at it. Yeah. Papers can't afford that anymore. Yeah, and even that news organization often gets charged. It's discretionary of whether the public body or the public entity charges or doesn't charge. Sometimes, back in my day, it was like, do they know you? Are you the reporter on the beat? Maybe you're more likely to get the records at no cost than somebody else, but I used to request public records all the time because I was a data journalist, and I didn't always get charged. Um, yeah, absolutely. Yeah. No, so I'm keeping a spread. Yeah, yeah. I'm doing Google searches and keeping a spreadsheet of who's raised it to the max. A lot of those are special districts. Right. I know that. I know that. I I did long time ago. I did lots of stories about that when I was at the Denver Post in the '90s. Yeah, yeah. Um, yeah, there's another issue with what's called the race to the courthouse, but I don't go into that. Uh, yeah. Right. They should not charge again. If that right, if that work has been done, I'm sorry for the first person who requested it, but that work has been done. You point to the statute and say if they can charge for. So if it's a criminal justice record, they could charge up to their quote actual cost. So if they've already done the work and it was their actual cost or whatever, okay. Same thing with Cora. If they've already done the research and retrieval, they can't charge again for that. No, they can't. So for criminal justice records, there is no free first hour, but for Cora records, they cannot not say that. They not do that. They have to do that. Yeah. So here's once again, I write about all these things on my blog. There's so much information on our website about this stuff. But yeah, I've counted. I think my last count was 340 that have adopted it. And every once in a while, I just do Google searches and find more. So some of those exceptions to Cora are in Cora itself. And like I said, others are scattered throughout state law. So is a section of Cora that allows the withholding of certain records or the redaction of certain information in records if the records custodian thinks it would be contrary to the public interest to release it. And then there's another section where they have to withhold certain information. So if you, for instance, contact state government and you provide your email or your phone numbers in there, that can be redacted There's, the town of Estes Park, the president's going to come to visit, and the town has records about what they are doing to prepare for that. They can deny that under details of security procedures, things like that. So there's stuff like that in there that are is discretionary. The mandatory denials include things like public school information, public school student information. That makes sense. Personal information of users of public utilities. I remember that thing I wrote about that's on my blog about big data processing centers and their water usage. Well, 2 judges says that that's not covered by this, so that's interesting. The books you check out from the library, the public library, that is not public information, but under a new law last year, if you want to get books banned or removed from the library shelves or moved to another shelf in the library, that request for reconsideration form that you fill out, that is now subject to CORA. There are certain things that are in that chunk of what I call mandatory denials that you have to understand a little bit more on how the courts have interpreted it. So personnel files is one of those things. And what we're talking about are personnel files of public employees, except it only means their personal information. So their home address, their home phone number, their personal financial information. It does not relate to their disciplinary files, things like that. So their performance on the job. I've already talked about this case, personnel files. This is probably the number one thing that we do battle over, whether it's, some of these things end up in court, but it's often just a lawyer letter saying you have to disclose these records. The town, some town employee was fired over something. The public has an interest in why. That termination letter, if they withhold that, that is not what this personnel files exemption is about. If they've been disciplined, that's not what this personnel files exemption is about. However, the legislature last year and the courts have now made these records essentially off limits to the public for public school administrators. And I'm amazed by this so there is a separate statute outside of CORA that talks about public school teacher and administrator evaluations. And the Court of Appeals just ruled that if disciplinary records are used to prepare those evaluations, the public can't get them. So you could have a school administrator accused of wrongdoing and not get those records, which is that's not how other public employees are treated. It's not how law enforcement employees are treated under the law. And this was kind of shocking. The previous one? This one, personnel records. Everything is in the guide. Everything, I have stuff in the guide about this. Yeah, and I wrote about this decision, so you could read about it. We would love to see the law clarified on this. Once again, it's really difficult to get legislators' attention on these things. Our organization, for the first time ever, just hired a contract lobbyist. We finally were able to afford to do that. There's not a lot of voices for the public's right to know at the Capitol. There's very, very few. There's a lot of government lobbyists at the Capitol. So emails and to some extent text messages are probably one of the main requested public record now. That is a very frequently requested public record, because if emails can give, reporters, other people, an idea of how government decisions are made. I like to tell college journalism students that public officials do not have to talk to you. The mayor of Loveland does not have to talk to the reporters if she does not want to. But, I'm sure you do though. But public records will sometimes speak for public officials when they don't want to talk about certain things. And so that's why reporters frequently request emails and text messages to get a much more complete picture of whatever story it is that they're working on. So emails. It's the content of the email that determines whether it is a public record or not. It has to pertain to public business. So if it doesn't matter whether the email was sent or received on a private account or a private device, it's the content. If it pertains to City of Loveland business, City of Estes Park business, that's what determines whether it's a public record or not. So there actually is some case law about this. Many, many years ago, the Arapahoe County clerk was having an affair with his deputy clerk. And the Rocky Mountain News and the Denver Post, I did not work on this story, were very interested in the messages that they were sending to one another on a county system. This is before all these things. And so this went all the way to the Colorado Supreme Court, which said that the messages pertaining to their affair was not the public's business. The messages that had to do with Arapahoe County was the public's business. If there was a message that contained both, like where are they going to dinner tonight, but also something about the county budget, the stuff about the county budget the public could be able to see. If it pertains to public business, so if an official is using their AOL account or their Comcast account to conduct city business, now it's harder to get at sometimes, right? Because you have to submit a CORA not just to the mayor, or I'm sorry, not just to the city of Loveland, but to the mayor herself, and say if any of these things are done on your phone, I want that too. Yeah. Exactly. It has to pertain to public business. So, and I'll get to a case about that in a second. So settlement agreements, I just want to mention that those are public records. If the city settles with some entity, that's a public record. There is something in the law called deliberative process privilege, which is very difficult to penetrate sometimes. And this is something that is claimed by government when they say that the material is so candid or personal that public disclosure is likely to stifle honest and frank discussion within the government. Of course, that perks everybody's ears because this is probably the good stuff, right? The interesting stuff. But governments will claim this, and then they have to actually attest to that in an affidavit. And then if you, as the reporter or the member of the public, still want to pursue it, you can force them into court. They actually have to go to court to get a court order about that. And sometimes you can get a judge to actually look at the messages, look at the documents, and decide whether it truly fits or not. I wanted to make sure I didn't. Did I go over that. I had a, maybe I didn't have this slide. Okay, so emails. I want to get back to that in a second because I had get back to that because I thought I had a slide about this city of Denver court decision about Red Rocks, a hailstorm at Red Rocks. So not this past summer, but the summer before that, there was a really awful hailstorm at Red Rocks that pummeled people, and they, they stopped the show, and some people ended up in the hospital and all that. So 9 News wanted the text messages, so Red Rocks is a city of Denver facility. So 9 News, Steve Steger wanted the text messages between the venue manager and the city arts, and I can't remember what her title was. Like, what were they talking about at the time when all this was happening, and then what were they talking about after the fact about this hailstorm that was people were injured in. And City of Denver, and this relates to your question, City of Denver says, these aren't public records, we don't keep them. Steve Sager called me and, no, they're public records. It's the content of the message that determines whether they're public records or not. City of Denver held to its position, and eventually this goes to court, and the judge says, of course they're public records. They had to do with City of Denver business, but what he had the employees do, one of their phones was a city-issued phone. The other one was their personal phone that they were using for city business. And he said, I don't care if the city doesn't, have a big repository for these messages. Go into the phone, make screenshots, do whatever you can to get these messages off. Go to the provider if you need to. Just do it. And we don't have case law from that because the city didn't appeal, but that's pretty good indication of how a judge would look at these things, because that's how the Denver judge looked at it. Yeah. 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 You're talking about as a constituent, right? Yeah. There. Yeah. That is in the statute that says that if you as a constituent want to tell the public official, please keep this confidential because I'm telling you something that's personal to me or whatever, then it cannot be corroborable. I think the same is true for when they respond to you, but I do think it is on you as the constituent to say that. That's how the statute is worded. Yeah. Yeah. Now the Estes Park, and I think Loveland does this too. Is that right? They put a lot of city council emails on most do not do that. I think that's great. I think that's a really good thing. Now I know that somebody goes through these and looks for, maybe things that might be privileged or whatever, but there's very few public bodies, public entities in Colorado that do that. That proactive disclosure, so you don't have to quora for something, is a good thing. I think that's right. I think the intent of that provision is for, you're saying I've got my child is ill with something, and if it's related to some personal need or whatever, I think that is I think that's the intent of what that is. By the way, I like your social media posts. Blue sky now, right? Yeah. Okay, so I wanted to make sure I brought up that Red Rocks case because I think that is pretty important, for them, when they just say, oh, not public records. Yeah. Yeah. I think you could certainly use Cora to try to get more and see what they're not. Yeah. Yeah. It's always, that's always the case with any Cora request where if you think something is being withheld and, you, first of all, you deserve that explanation of why it's confidential, but you want to challenge it, you often need like some sort of evidence that it's actually not confidential. Maybe there's some other person who was involved in the conversation or the message that, supply some evidence of that. That's a really hard thing sometimes to get at, because you don't necessarily know what they're keeping from you, what they're not producing. Just another thing to keep in mind, if you are interested in public records that are kept in spreadsheets and databases, you can get them in those formats so you can do analysis on them. This is something that we push for and got. That's minus any fields that are confidential. So a database that has a social security number in it or something like that. So that can be handy sometimes. So challenging a denial of access. Once again, these laws, Cora, like the open meetings law, is enforced in the courts, in the district courts. So there's no administrative appeal process. You can't go to the AG. If you're going to do this, you have to provide 14 days notice of intent. But during that 14 days, the records custodian is required to have a conversation with you about your request to try to keep it out of court. Sometimes that can get things going, and it doesn't have to end up in court. We have a lot of information on our website in that guide about writing the Cora letter. We have a template in there. And what's really important, first of all, this is a common mistake. You want to ask for records. You don't ask for information. You don't ask questions. Public officials are not required to answer your questions. They are required to provide public records if those records exist and they're not subject to some exemption in the law. So you're asking for records that may contain information that help you get your questions answered. But you're not just saying, please tell me blah, 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 like that. The other thing that's really important, I always say, ask for an estimate, how much this is going to cost me. And then also, you are entitled to a written explanation of any grounds for a denial, and that includes redactions as well as just an outright denial. Include that in your request up front to make sure that they do that. Most will do that. If they're going to deny you, they will explain it. Occasionally, you don't get that. And if someone says, and I hear this, we have no records responsive to your request, ask what that means. Because I think, I don't, this is one of those training things for records custodians, I think. Some of them that may mean what it sounds like, that we did a thorough search and there's actually no records. I've actually heard where some of them mean we don't have any records that can be released. Well, that flies in the face of their responsibility to explain why they can't release it. So if they say that, get an answer to what that means. Are you denying me, or are you saying there is absolutely nothing there? We'll go really quickly through the Criminal Justice Records Act. Very different presumption of openness. So I mentioned in Cora that you can make an assumption that the records you want are open for inspection unless some exemption applies. Criminal Justice Records Act, for a lot of records, the records custodian can withhold them, the police department, the county sheriff, whatever, by saying, we think this would be contrary to the public interest to release it. So that, if they do that, so there's a very, very small set of records of official action that have to be released. Those are really just like a basic arrest report. So-and-so was arrested. And this is when they were arrested. This is what the charge was. It's not, reporters are often interested in the arrest affidavit, which is that narrative explaining why someone was arrested. That can be withheld, at least for, time being, because it's not a record of official action. So if they tell you that it would be contrary to the public interest, they are supposed to have conducted a balancing test of interests to make that determination. This is a ruling that came out of Columbine, Harris versus Denver Post, Eric Harris, one of the Columbine killers. And what they're supposed to do is balance the public interest against any privacy interests and the agency's interest in an ongoing investigation, which is often why you don't get a lot of records released quickly about a criminal justice issue. And then there's sometimes other things as well. People are mostly interested, reporters are mostly interested, because there's a public interest. So they keep arguing for those things. You also, if they claim privacy on something, you can cite case law that says that they should use redaction and release the rest, or whatever they can release of records. We helped get something passed in 2019 that opened up police internal affairs records. So when police are investigated internally for misconduct, and you've had an issue, a very high profile case in Loveland. Well, I'm thinking of one in particular, but anyway, so before 2019, nearly all law enforcement agencies in Colorado would not release these records, police internal affairs records. And this is only related to incidences of alleged misconduct involving a member of the public while an officer is in uniform or on duty. So it's not the officer who gets drunk in his car like happened in Aurora a couple years ago. That internal investigation could still be withheld as contrary to the public interest, even though it might be in the public interest. But if it's a police shooting or it's some other allegation that relates to an interaction with the public, once the appeals are exhausted, those records are can be released to the public. So that, I think, was a very important law for police transparency and accountability. And another one was passed in 2020, relates to police and body cam footage. And like the internal affairs thing previously, law enforcement agencies would deny this or delay the release of body cam footage, saying it was contrary to the public interest. And now there's a timetable in the law. If the video relates to an incident of alleged peace officer misconduct. So this is still not always complied with. There's a couple of instances involving the Aurora Police Department right now where they have not complied. So this is something that may require some more litigation. We just had a case in Boulder that is now on appeal regarding the fees that can be charged for body cam footage. So a woman was shot and killed by Boulder police, and for news organizations and the daughter of the victim to get the footage, Boulder wanted thousands of dollars. So what is the point of having a law that discloses the footage if you have to pay thousands of dollars to get it? So a judge in Boulder said, there's nothing in the Law Enforcement Integrity Act, which is what this is under, that allows the charging of those fees. And now the city of Boulder is appealed. So we'll see what kind of case law we get out of this. We're going to be doing an amicus brief in that. Jail logs, that's a 100-and-something-year-old law where you can always know who's in the jail. That's a very reliable public record, I think. You mentioned cost of criminal justice records. It works differently than Cora. They can charge up to their actual cost. Sometimes it's very difficult to pin a criminal justice agency down on what that is. And you have to sign a form that says you're not using the records to solicit business for pecuniary gain. The sponsor of the Cora bill, Kathy Kipp, is trying to get something like that into Cora as well, which some people who request public records for commercial purposes are not going to like. As with Cora, in order to challenge a denial, you have to go to court. Unfortunately, it's very, very difficult to get courts to overturn denials of criminal justice records because you have to show that the records custodian abused their discretion. That may not be the case for body cam footage and internal affairs records because they're kind of more specific in the law about that, but just criminal justice records in general, like an arrest affidavit or something like that. There's a lot of restrictions on getting records about juveniles involved in crimes, not just the people who are accused, but also victims and witnesses now. Those laws have gotten more protective. So that's what I've got. Any other questions? Really, once again, our website, coloradofoic.org, has just a ton on it. You could always email me. Contact information is on there. It's jroberts@coloradofoic.org. And we're on social media. We're on Twitter and Blue Sky and Facebook, LinkedIn. Yeah. So one of the editor of the Colorado Sun is a board member of CFOIC. I have had articles in the Colorado Sun, but sometimes the articles that I write get republished in other places. So, and occasionally we'll do op-eds that end up in the Post or the Sun or something like that. Yeah, I think they should have rules about that. I think they should make it clear to the public if that's how they're going to meet on Zoom, then it should be, they should have rules about not turning your camera off and not messaging with one another during the meeting. Or if you're going to do that, make sure the public can see that conversation. Also, we're a 501c3 if anybody wants to support CFOIC. That's how we stay in business.
That's one of the reasons I came up here, is I want to tell you that you will get, if those of you who did register with us to come today, thank you very much. you'll get a follow-up email thanking you, and we will do an article that will also tell people how they can support this organization, Colorado Freedom of Information Coalition. One of the things I thought of while I was sitting here today was the Washington Post phrase that democracy dies in darkness. We need journalism. We need public journalism to help us to get the information out about what our public bodies are doing. I don't think people join public boards either to be appointed or to be elected for nefarious reasons. I really don't. I sometimes hear all kinds of comments about, oh, you know, politicians. Well, I don't think most people do. They enter public service because they want to serve. But it's important that we do good education. So thank you for coming today. I hope you can bring some of this information back to your groups and boards. I do want to commend the town of Estes Park for the way they deal with their emails. I think it's a really good model that other public boards should do, that the board members of every public board should have their emails available so that the public can access those. It's the public's business. It needs to be done transparently. Jeff, I really want to thank you for coming today. One of our reporter, writer, journalist people, Hank Lacey, wants to make a comment too about federal Cora. Yes. And just thank you, and I'm going to leave the microphone with them.
Uh-oh. Uh-oh. Yes. Thank you very much. I neglected to mention that we put out a newsletter, an emailed newsletter, which you can sign up for on our website. There's a newsletter tab, and it's just it's stuff that we write. It's stuff that I assemble from all over the state about open government, First Amendment issues. I send it out probably an average of every 3 weeks, sometimes a little bit more often. It's really when I have a lot of stuff, I send it out. Sometimes during the summer, it might be every month. But if you want to know more about this stuff and you want to keep in touch with us, that's one way to do it.
I just want to say a quick word about the Freedom of Information Act. You know, we don't have time to get into it too much today, but as local officials, you might want to be aware of that, particularly in light of last week's hubbub over the grant freeze. You know, getting information from Washington can be challenging. As reporters, we do it all the time. We use FOIA. You can too. So that's a whole different topic. And also take note of the Federal Advisory Committee Act that allows you to get information about what advisors to federal agencies, including the White House, are doing. So again, not a lot of time on that today, but make a note of that.
Thank you, guys.